Speaker, in talking to this bill, I can say that the Māori Party is pretty proud of our stand in placing the Constitution firmly in front of our coalition arrangement with the National Party, and in pretty much hopefully standing strong in our determination to support human rights of all people by ensuring their access to justice. So the call for justice, after all, is what motivated our work to reverse the previous government's decision not to sign up to the United Nations Declaration on the Rights of Indigenous Peoples. Access to justice, specifically through restoring access to the courts, has been pretty pivotal in our role with the Marine and Coastal Area Takutai Moana Bill that will be heading to the House in the next week or so. So, sir, we come to this Legal Services Bill with a view to understanding how this bill, in replacing the current Legal Services Act 2000, will improve the situation for all New Zealanders. Mr. Speaker, there's no denying, I think, that reform needed to happen. Dame Margaret Baisley, as others have mentioned tonight, left no room for doubt when her review highlighted a range of deficiencies within the legal aid system. These, sir, included the variable quality of legal aid services as well as some serious service delivery issues. Mr. Speaker, a key recommendation from the Baisley report was that, quote, stronger coordination between community law centres and central government, end of quote, is needed to ensure community law centres are able to help the greatest number of people for the funding that's available. And we've taken a particular interest in the potential of this bill to ensure much needed services for Māori can in fact be continue to be delivered. As Dame Margaret said, quote, if the legal aid system fails Māori, the system fails altogether. Mr. Speaker, as elected MPs, each of us will have had experiences of clients who have alleged that their lawyers are incompetent or corrupt. We've heard too many stories of legal aid lawyers dragging the legal process on for long periods of time, indefinitely, to get repeated chances at fees. It's what Dame Margaret reported as milking the system. And there are plenty of other stories of legal aid lawyers who have recommended guilty pleas rather than actively taking up the interests and rights of many of their Māori clients. And of course the stories of delays and deferrals are fairly legendary. Mr. Speaker, we all remember the situation of the 19 defendants caught in the spotlight, if you like, of the 15th of October raids on Ruatoki. Their applications for legal aid were lodged more than 4 months before they began to be processed by the Legal Services Agency. So I remember that at the time that Dame Margaret's recommendations were released, Annette Sykes shared her view on Te Karere that she approved of the changes to invest in the competency of the legal aid lawyers because it was her view that too many Māori were frustrated by the poor quality of the work undertaken by the lawyers. What Dame Margaret's report revealed was that there was a small but significant group of lawyers who were abusing the system, sir. We welcome the move from this bill to the effect that lawyers will now have to sit competency tests before going on the legal aid roster. But we would also hope that the brush is applied more widely and not just target a particular court or a particular region, as has been discussed by the member for the Green Party. Mr. Speaker, our key focus in looking at this bill is exactly how it will support the specific needs of Māori. These are all important steps, and we hope that along the way the Minister would see fit to reinstate funding for Māori legal services. We have a particular interest with legal services and believe that it will be an improvement to have legal services under the scrutiny of Parliament. We want to see that legal aid will address the needs of peoples with insufficient means within Aotearoa. This is a particular interest I want to raise. So there is a particular matter that I did want to raise around the intention of the bill to clarify that legal aid is available for Waitangi Tribunal proceedings, but not negotiations with the Crown to achieve a settlement of a claim. Mr. Speaker, I do recall that at the end of 2009, the late Sir Atawhai Taiaroa Sir Tai Hakure, Eddie Jury, Mātānuku Mahuik and other representatives met with the Minister of Justice to express concerns about the number of lawyers appearing before the Waitangi Tribunal and the consequential loss of tribal control over their claims. It was proposed that a small group should meet with the Legal Services Agency and the Waitangi Tribunal to search for alternative proposals that would retain the benefit of legal aid but place controls on the number of lawyers and the consequential expenditure of that. The Ngāi Tahu Māori Law Centre brought a particular insight to the issue. They are a community law centre based in Dunedin that specialises in Māori land law. It was their view that, and I quote, moving the funding of negotiations between claimants and the Crown from the legal aid system to be funded solely by the Office of Treaty Settlements leaves open the potential for the funding of negotiations to be unduly influenced by those who negotiate with claimants on behalf of the Crown, end of quote. So, Mr Speaker, I will be interested to hear from the Minister how the views of Māori leaders and the submission from Ngāi Tahu has been taken into account with the bill as it emerges from the Select Committee process. And we will be interested to know what will be the nature of the tests put in place for Māori to apply for such funding. Mr Speaker, I'm aware that the challenge was issued by Dame Margaret that there be incentives in place to support the specific needs of Māori, and some of the comments from Annette Sykes gives me reason to believe the changes around the competency of lawyers will be positive. But there are some real concerns about also around the removal of the Public Advisory Committee, something that both Ngāi Tahu Māori Law Centre and the Coalition of Community Law Centres both spoke against. We want to see community input and consultation retained in the administration of legal aid, and we want to know how the Legal Services Commissioner and the new Quality Assurance Framework will take this into account. But let's be clear, our preference would have been to retain the Public's Advisory Committee to ensure the involvement of the community. We do support disestablishing the Legal Services Agency and shifting responsibility to the Secretary for Justice, and we also support the approach of all legal aid lawyers having to demonstrate competency. But we remain concerned about the removal of a specific community input, and our vote at the final reading will be determined by discussions that we have over the successive stages to assess whether Dame Margaret's warning has been addressed. As I say, the warning was if the legal aid system fails Māori, the system fails altogether. I'll leave that for the consideration of the House, and the Māori Party will be supporting this bill its second reading.